Hello everyone, and welcome to the Marine Money webinar series. I'm your host, John Chair, and I'm very excited for today's topic, US and Cayman Islands restructurings, applicability of recent innovations to the maritime industry. This collaborative webinar between Maples Group and Reed Smith is a timely one, as we see our capital-stricken industry be put under more pressure from the COVID-19 pandemic, which in turn has made the already levered and complex capital structures fairly unsustainable. Luckily, we have four experts here to take us through how we may respond to this threat through restructuring, specifically through US and Cayman Islands law. Today, we have two representatives from Maples Group. We have Caroline Moran, who is a partner at the group and advises on all aspects of cross-border and domestic insolvency and restructuring issues, and has vast experience in commercial litigation. We also have Nick Herrod, who is of counsel for the Maples Group, joining us today. Nick has over 20 years of experience dealing with insolvency and restructuring practices for the industry and has over 5 years dealing with the Cayman Islands specific law. We have two partners joining us from Reed Smith. They are Greg Chase and Aaron Javian. Greg is not only a partner, but is also head of shipping for the Americas for Reed Smith. In this role, he advises on clients in a broad range of ship finance and shipping-related private equity matters, everything from cross-border and domestic transactions to debt restructurings. Aaron is also a partner of the firm and represents a wide array of clients of all aspects of domestic and cross-border in-court and out-of-court financial restructurings and insolvencies. Some past work you may all know of his would be the administration of Lehman Brothers Europe and the liquidation of certain Asian affiliates of MF Global. So, as you can see, we have a star-studded cast here to take us through how to navigate restructuring should you need it. And before I hand it over to the team to kick this off, here are a couple of tips for those who are new to our webinars. For this webinar, the audience will be on mute. We do this to ensure audio quality control. But during this webinar, you'll have the opportunity to ask questions to the panelists. This is the whole reason we do this live. So please take advantage of this and ask questions to the panelists. To ask a question, simply enter your question into the text box at the bottom of the control panel where it says questions, like shown on the screen in front of you now. I will receive them, and at the end of the session, I will ask them on your behalf. Finally, if you'd like to collapse your menu to see the fantastic talent we have today, simply click on the orange/red box arrow that is on the top of the screen, and that should collapse the menu. So now, without any further ado, I'd like to hand it over to Caroline to kick this session off.
Thanks a lot, Jonathan, and thanks for helping to organise the panel and for giving us all the opportunity to put on shoes this morning for a change. And good morning to our audience, and thank you for joining us. I'm Caroline Moran from Maples and Calder, and I'm based in the Cayman Islands. I think in the current environment, as everybody is well aware, where it's obviously a lot of distress in the market across various industries. And in this morning's presentation, we wanted to take a look at some interesting trends that we're seeing in the restructuring world, where companies are seeking to restructure their balance sheet and why they might be relevant to a marine money audience. And in particular, we'll be talking about why companies seeking to restructure their balance sheet might want to or might be required to consider a restructuring in the Cayman Islands, as opposed to the more traditional route of a Chapter 11. And we often find that in circumstances where a company's lenders are hedge funds who've bought into the debt rather than traditional lenders, there's a much bigger focus on exploring restructuring options in jurisdictions other than the United States. And that can lead companies and creditors to the Cayman Islands, which is a particularly good fit for shipping companies incorporated in the Marshall Islands who have issued New York law governed debt. I think that's going to be the focus of our presentation today. And then, of course, who better to team up with for the purpose of a presentation relating to shipping, but Greg and Aaron from Reed Smith. So Greg, what are you seeing at the moment in the shipping industry in your practice? Well,
thank you, Caroline. Good morning, everyone. And for my part, thanks to Maples Group and especially Caroline and Nick for inviting us to participate this morning. As Jonathan said, we handle shipping transactions in New York. We work on a full range of traditional finance and corporate matters. But we also team up regularly with our colleagues in other practice areas in our firm. And on the restructuring side, Aaron and I have been working together regularly. Of course, even before the current crisis, it was increasingly difficult for ship owners to raise capital, even though we've seen an expansion in recent years of the sources of capital available. But certainly in the current environment, fundraising has become more fraught than ever. We have seen new deals for sure in the last several weeks, but it's probably fair to say that they're moving more slowly than we would typically see. Much of the activity, though, even with this new money, is coming from what I would call alternate sources. They often operate on a hedge fund model, and they're exactly the kinds of lenders that I think we're going to focus on a bit today. In recent weeks, though, we've also seen a sharp uptick in vessel arrests across the US and in other parts of the world. We've seen a number of arrests made not only by mortgagees, but also by maritime lien claimants, typically vendors to vessels. We find this very important because even though borrowers may be able to convince their lenders to accommodate them during the COVID crisis, an unexpected arrest by a vendor can force a lender into a proceeding. Along with the new money deals, as they're going along, we're also seeing a lot of our clients in existing deals talking to their lenders about restructuring, trying to figure out what their exposure may be with respect to different covenants as the crisis wears on. And we do think there's a significant potential for a new wave of restructurings, potentially in court across the industry. This presentation will lay out some of the considerations relating to the choice of jurisdiction for an in-court process.
And thanks, Greg. And I think when you look at the planning for the next phase box of the slides there, one of the things that we'll be thinking about is there's new money available at the moment, and there may be capital available down the line, but the question will be, will people want to lend out of a court process? And if COVID goes on, and you find groups where all available assets have been taken for security, we might see new money deals and restructurings in court rather than out of court. And of course, the question is, well, can you choose your forum for a restructuring? And the answer of the US and the Cayman Islands court is very clear. If you're looking at good forum shopping, which we'd say is forum shopping for the advantage of your creditors and stakeholders. So for example, a Cayman Islands scheme is shown to return more money to your creditors. The US and the Cayman courts have endorsed that type of forum shopping. So you shouldn't be shy for looking around for the best restructuring to fit what you need to do if you do find yourself in that scenario.
And Nick, I think it makes sense now for us to talk about what happens before a decision about where to file a potential restructuring is made, and what stakeholders should be looking at, both on the lender and the borrower side, in the context of potential distress. If we go to the next slide, every restructuring is different. And part of what makes every restructuring different will be the roles and the stakeholders who are involved in a particular situation. So to understand what options may be at play, it makes sense for parties, both borrowers and creditors, to think about who the relevant parties are. And by this, I mean on the company side, it's important to understand not only where is management located, but what's the background, what jurisdiction is management comfortable practicing in and doing business in? Are they coming from a continental European perspective? Are they coming from a UK Commonwealth country perspective? Are they coming from a US perspective, or a mixture of all things? This background goes to the level of comfort that management may have with various restructuring regimes. Other factors on the company side to take into account is how closely held is the business? Is it publicly traded? Who are the ultimate stakeholders on the equity side, and what's their interest in conducting a restructuring? A similar analysis should take place on the creditor side. Are the lenders relationship banks? Are they alternative capital providers that provided financing at par, sort of like shadow banks? Or are they hedge funds that bought in on the secondary market, potentially at distressed prices? Do the lenders otherwise have credit insurance? All of these factors go to what the motivations of the lenders will be in a particular restructuring situation. And creditors don't just stop with the lenders. It also, as Greg mentioned, includes vendors and maritime lien holders and other parties that may have relevant claims that need to be dealt with in restructuring. So this is one starting point for the consideration of what jurisdictions and restructuring regimes to think about. And what those parties are going to be doing is really performing legal and commercial due diligence in light of distress. And where the rubber hits the road is going to be in terms of cash flow projections, valuation issues, and covenant compliance. Looking at and understanding what the consent thresholds are in relevant transaction documents. Looking at the context of intercompany relationships, cash management, claims of affiliates where affiliates are providing operating and management services to a shipping entity. All of these factors require analysis both by the company and the creditors in order to figure out what the right restructuring might look like to meet their needs, which is why hiring advisors, financial and legal, can be so important. And the output of this diligence and thinking about the stakeholders is going to be coming up with contingency planning. On the company side, it's going to be identifying what the right cost structure is going to be for the business and what level of debt is sustainable, and then coming up with plan A, plan B, and plan C to implement that, whether it's through out-of-court means or in-court means, and potentially through various jurisdictions that might be beneficial to the company. Similarly, lenders are going to be having that analysis, trying to consider whether it makes sense for them to go it alone and follow enforcement proceedings, or whether it makes sense for them to team up with other creditors to try to come up with influencing restructuring in that way. And these are the considerations that we see regularly in the US. Carol and Nick, I imagine you see similar things from the Cayman perspective. Would love to hear your views on this from the offshore space.
Yeah, I mean, I think that's a great point, Aaron. You know, what we see, as I know you do, a good restructuring is a collaboration in the decision making between the lenders and the borrowers, and the decision on jurisdiction is not made in isolation. It's very much an iterative process. I think what's quite interesting is over the past few years, we are seeing and we are being asked more and more to give presentations, explaining the differences between the jurisdictions, and seeing parties focusing on the jurisdictional analysis as a key point of this decision-making process. And typically when restructurings end up in the offshore jurisdictions such as Cayman, that is done with creditor support. So for example, in the ocean rig restructuring that I know this audience will be very familiar with, we had 4 interlinked schemes of arrangement carried out very successfully in Cayman in an extremely contentious situation. And the choice of Cayman as the restructuring forum was very much supported by the key creditors in that restructuring. And indeed, that was a big point for the Cayman court when we were persuading the Cayman court that it was appropriate to accept jurisdiction and carry out the restructuring in Cayman, that so many of the creditors wanted the restructuring to be carried out there. And Nick, I know you obviously work quite closely with our BVI and Irish offices across a number of the restructuring deals. What are you seeing in those jurisdictions?
I think in the BVI, we're still seeing the more traditional model where the main proceedings are outside of the BVI. It doesn't mean the BVI couldn't lead a restructuring. And an example there is the recent Constellation restructuring in the rig business, where you had the Brazilian filing and you also had BVI filings in support, and you had the Chapter 15s, and we'll come on to discuss why Chapter 15 is important shortly. Ireland's more interesting. Ireland's recently had a scheme of an aircraft leasing business, and that's the NACDAC scheme. And we'll discuss why that's really innovative, but they flipped the scheme on its head. And it's a cross-border scheme, and it's a huge number of entities filed. And that really shows that Ireland, I think, is a jurisdiction to be watching right now. You've got the Brexit considerations from the UK. I know they've implemented their new law. So I think Ireland's a jurisdiction to be considered, more probably in the aircraft space than the space we're looking at now. But we're certainly seeing activity in the less traditional jurisdictions, so outside of the UK and the US.
Okay.
Does it make level sets with the structures we typically see in the shipping space?
Yeah. If we could have the next slide. Okay, so as we dive into this in more detail, this slide sets out a typical shipping or offshore company entity structure. Of course, each company will have its own setup and its own features, but we think this is generally representative of the key features we often see, and we think it's useful to kind of frame a reference for our discussion. Many platforms are organized into separate silos, with each silo corresponding to a separate financing transaction. Each silo typically has a topco, which functions as a holding company for entities in that silo. The topco will then be the 100% equity holder of any number of single-purpose asset-owning SPVs below it, each of which will exist solely to own a vessel. These days, the topco and vessel-owning SPVs are often organized as non-resident companies in the Marshall Islands. Many times, the topco will be the borrower or the issuer in a financing, and each of the vessel-owning SPVs will provide an upstream guarantee. These guarantees will then be secured by vessel mortgages and other customary collateral. A very similar structure might well be deployed in an offshore company. It might be more likely that the offshore company has unsecured debt at the parent level, and that's represented in the diagram. Vessel management services are normally provided by affiliates or third parties, and some more complex structures may have separate cash management entities or operational affiliates. Revenue streams are likely to be collateralized across the entire structure. So I think the takeaway for our discussion today is that these platforms are very international. They may not have a home jurisdiction that's obvious. The Marshall Islands does not have a bankruptcy code. And this means there may be a range of viable options for choosing where to do a restructuring when an in-court process is required.
Yeah, agreed, Greg. And if we go to the next slide, we'll lay out, I guess, the one regime that's clearly relevant, which is Chapter 11. And just to quickly provide reason why Chapter 11 becomes relevant in the shipping context where you've got complex cross-border organizational structures. First is because there's a very low jurisdictional bar to qualifying for US bankruptcy court jurisdiction. In addition to that low jurisdictional bar, there's a lot of bang for the buck when you file in the US. Filing, just by virtue of filing, gives rise to a worldwide automatic stay of creditor action against the debtor and its affiliated entities that have filed. The debtor and its management remain in possession and can operate the business following a bankruptcy filing. There's opportunity for the debtor to obtain financing post-petition on a potentially priming basis to pre-petition lenders, which creates incentive for new financing to be raised so that the debtor can, in fact, continue to operate through bankruptcy as a way to maximizing value. In addition, the Chapter 11 has a strong ability to implement a financial restructuring through the plan process, which allows the company to cram down potentially dissenting classes, and also to gain the consent of creditor classes with a 66 2/3% voting threshold in amount and half in number. So plenty of ability to have a financial restructuring, and then also an ability to do an operational restructuring in Chapter 11 because of the powers of the debtor to assume and reject executory contracts, the business contracts that the business requires or would like to shed that have led to its economic distress. So with those types of tools, it's no surprise actually in the current environment that we've seen an uptick in Chapter 11 filings generally post-COVID. That's particularly in the retail space and consumer. But for this audience in particular, we're seeing an uptick in oil and gas and in transportation. On the oil and gas side, there have been a number of offshore drilling companies that this audience will be familiar with that have filed, including Diamond Offshore, Noble, and Valaris. There's rumors in the market that this is just the beginning in the offshore space, given where oil prices are. And then interestingly, in the transportation side, although we haven't seen the big shipping companies looking for protection as of yet, there have been a number of non-US organized airlines that have filed for Chapter 11 protection, including LATAM, Avianca, and Aeromexico. And so on that basis, Chapter 11 continues to be a viable option, but it's not the only option. It's not the only tool in the toolkit. And Carolyn, I'd love to hear more from you just about sort of the scheme and what options that provides for parties looking to implement restructuring.
Yeah, absolutely, Aaron. And I should say we in the Cayman Islands are very jealous of Chapter 11. It's a great tool that really doesn't have a comparison, and in many circumstances you're going to want and need a Chapter 11. Where the Cayman Islands can provide an alternative is if you are looking at a more focused financial and balance sheet restructuring. And in those circumstances, this scheme can be a great and very efficient tool for a more focused restructuring. And the scheme and the court's role in the scheme, importantly, is limited to only 2 court hearings. So the first is seeking permission to convene the scheme meetings, and the second is to sanction the scheme. And apart from those hearings, the debtor can really continue business as usual without having the company subject to the supervision of the court generally during the scheme process. And I know Nick is really going to talk about that in a little bit more detail. So maybe we just sort of set the scene. I'll take a step back and talk a bit about the restructuring regime that we do have in the Cayman Islands and how the scheme interplays with what we call a restructuring provisional liquidation. So we don't have a standalone restructuring regime similar to Chapter 11 in the US or administration in England. And instead, we use schemes of arrangement to compromise debt, coupled with a restructuring provisional liquidation if you need a stay on proceedings from your creditors. And for a quick recap on schemes, for those who may not have come across them recently, schemes are a court-supervised process where a debtor can obtain a court-sanctioned compromise of its debt. And schemes follow a very similar process to a Chapter 11 plan in that the company formulates the terms of the scheme or the plan to compromise the debt, sends out a disclosure statement convening creditors to class meetings. The creditors are then asked to vote on the scheme or the plan, and assuming the statutory majorities are achieved, then the court will be asked to sanction the scheme. And as I said, that involves the two court hearings. Now, filing the scheme by itself doesn't give the company a stay on proceedings in the Cayman Islands. And going back to the point that Aaron made at the outset, whether a stay is necessary is going to be part of the analysis when you're formulating your restructuring at the beginning. And it's going to depend on the support and the composition of your creditor body. So if you've got very large levels of support from your creditors and your scheme is really just to tie up the disengaged outliers, you may decide that you don't need a stay during the scheme process at all. But if you are concerned about hostile creditors potentially disrupting your restructuring and looking at ways to come to the Cayman Islands seeking to derail the scheme process, then it's possible to obtain a stay by seeking the appointment of what we call restructuring provisional liquidators. And these are independent insolvency and restructuring professionals that are appointed by the court. Now, that can sometimes be a little bit difficult for management to swallow, but I can reassure you that this is a well-trodden path, and the role of the restructuring provisional liquidator is very light touch, and is to really assist the directors in implementing the scheme. So the company and the directors can continue in a debtor in possession proceeding, notwithstanding the appointment of the restructuring provisional liquidators. And our court is very well used to that situation, as are the insolvency practitioners in this jurisdiction. And once a restructuring provisional liquidator is appointed, that prevents all unsecured creditors from commencing proceedings in the Cayman Islands. And I should note that the stay is territorial to the Cayman Islands. It doesn't prevent, it doesn't purport to be extraterritorial in the same way as the US bankruptcy stay. And it also doesn't prevent secured creditors from enforcing security in the Cayman Islands. Now, you might say, well, in those circumstances, is there really any benefit? Because surely in some circumstances you do need protection from your secured creditors. So in those circumstances, what we do is, particularly in circumstances where the company has issued New York law debt and its key creditors have a US presence, we will look at applying for Chapter 15 relief. And then that gives the company the benefit of a stay on proceedings in the US, including on the secured creditors. And just before I turn it back over to Nick, I should say that we recognize that the term liquidator really does give a bit of an unfortunate branding problem, and can often find it difficult to get creditors and management comfortable that we are still talking about a restructuring. We're not talking about liquidation. So we do have legislative reforms on the stocks, hopefully that will be implemented by the end of the year, which updates our restructuring regime and puts in place a freestanding restructuring officer regime, moving away from the liquidation terminology, which hopefully should be more palatable to stakeholders. And the new regime, it's going to mirror a lot of the good points from the old regime, which works very well, with just a couple of extra advantages. So it will provide that the stay is extraterritorial, not just territorial to the Cayman Islands, and the stay will also arise on filing of the application rather than on the appointment of the restructuring officer. So in that way, mirrors the Chapter 11 stay. So Nick, I'll turn it over to you now to a subject that I know is very dear to your heart, which is what are the advantages of a scheme when compared to a Chapter 11 in the right circumstances.
Thanks, Caroline. If we could have the next slide. And I'm just going to say I love schemes, and I'm not ashamed to admit it. When you're looking at a scheme against a Chapter 11, and you're looking at a targeted financial restructuring, I think the first thing to say is the cost. The scheme can be cheaper to implement. As Caroline said, there's only 2 court hearings, and there's no creditor committees. So you've got less of an ability for fee burn for parties involved in the process. So the cost can be usually cheaper. Now, what the scheme can't do, as we've said, is operational restructuring. So if you need to restructure not just your debt, but you need to restructure the operations of the company, I'm going to give you Aaron's number and you'll call him quite quickly. If you need to deal with all of your creditors, we can do it via a scheme, but I think the cost point drops away, and so you're looking at a different set of comparators as to which proceeding will be the best. Now schemes are quick. Obviously, the commercial negotiations are had up front, as they would be in a pre-pack Chapter 11, and they will take as long as they need, or as long as the company's got in terms of the burning platform. But from filing, the scheme can be completed within 6 to 12 weeks, so it's usually quicker than the Chapter 11. Also, if you've got hostile creditors, the ability for creditors to make mischief in a scheme is lower. There's no discovery. There's one document the creditors get, which is an explanatory statement, which is sent out from the court after the first hearing. And so there's less court hearings. So when creditors do get their opportunity to have their say, but they don't get so many court hearings to turn up and make mischief and put pressure on the company. The moratorium, as we've said, if you need a really hard moratorium worldwide with a huge stick to wield behind it, there's nothing to beat the US Bankruptcy Court. The Cayman moratorium is unsecured and territorial only. Even with our restructuring officer regime, it's extraterritorial, but I don't think the Cayman court has such a big stick as the Bankruptcy Court, although no hedge funds are incorporated here. I think tax is a significant advantage. So if you're having to shift certain of your operations for a restructuring for jurisdictional requirements or center of main interest, which we'll talk about in a second, then the Cayman Islands is tax neutral. So you won't be moving to a higher tax jurisdiction such as the US or the UK, which obviously has business advantages. And if you want to release third parties through your restructuring, and by that we mean entities that aren't filed, debt obligations that they owe, the scheme is very flexible for the release of the third party debt and more flexible than the Chapter 11. And now Aaron can come in and tell me where I've completely done Chapter 11 down and correct me.
Well, look, Nick, you haven't completely done it down, and the scheme is a very viable tool, to be sure. I think the few points I would make on what you said is that, look, Chapter 11 has had a mixed record in the shipping space, particularly for the cost reasons and the ability for creditors to go to court and raise issues that reduce value for everybody at the end of the day. But where Chapter 11 has been most effective in the shipping space is in the prepackaged or prearranged plans. And that's really the analog to a scheme as opposed to a free fall Chapter 11. And so on that, I think that, and you're also right to note that there's a different practice in the US with respect to third-party releases. And so the practice in the US isn't to file one entity that is the issuer and have that schemed, but rather to file all of the obligors under the critical debt documents through a bankruptcy process. So it is a blunter instrument in the sense of the number of potentially affiliated entities that will need to go through a bankruptcy process. Now, from a U.S. perspective, those additional filings don't really increase the cost too much, but it definitely is a blunter approach than the scheme. I think the interesting difference, in addition to the sort of court supervision that you've noticed, is that there are just some legal differences in terms of the confirmation threshold for a Chapter 11 plan versus a scheme of arrangement. One is that in the US, the company needs to, with a straight face, say that their plan is feasible. And so what I've seen is that Chapter 11 plans going through the US bankruptcy process, there tends to be reduced debt burden on the company relative to schemes where the creditors can simply agree what the appropriate new debt burden should be. And so that's an important difference depending on what side of the line you're on in terms of what the outcome would look like in a scheme versus a Chapter 11. The other issue is, to the extent that in a Chapter 11 case, the company is looking to impair creditors, unsecured creditors, that creates issues with respect to retaining value for old equity. the absolute priority rule kicks in, and there are workarounds to the absolute priority rule to provide that old equity can continue to have a stake in the reorganized company, but there needs to be additional planning for that. Whereas in the scheme, it's possible to just do a scheme of creditors and leave equity in place. So, there are, I think what you gets the nitty gritty in terms of scheme versus Chapter 11 is really that those legal questions about what the parties' goals are in the context of restructuring and what regime really makes the most sense.
I think if we could just pop on to the next slide, please. I think one of the questions that we often get is, well, I don't have any Cayman Islands companies in my structure, so how can I come to Cayman Islands, or why would the Cayman Court be interested in hearing from me? And I think that the short point in those circumstances is, well, much like a Chapter 11, it doesn't really matter where you are incorporated. There is the ability in the right circumstances for the Cayman Islands Court to have jurisdiction and to accept that jurisdiction and exercise it. So on the jurisdiction point, let's just, for the purpose of this slide, I'm going to assume that we're talking about a group that has Marshall Island companies and does not have any Cayman companies in the structure. So you've got a few options to form the jurisdictional hook for the Cayman Islands. The first is you could create a Cayman Islands co-issuer for the purposes of finding jurisdiction. The second is an option to actually continue one of your Marshall Island debtors into the Cayman Islands, and that involves the Marshall Islands company effectively reincorporating as a Cayman Islands company. That may or may not be palatable, and it also may or may not be possible depending on how early you're coming, because the directors do need to swear a solvency declaration. So there is probably a short window before the company becomes technically insolvent where that's an option. But if you're coming later in the day, that may not be possible. So the third option, which is probably the most user-friendly, is simply registering your Marshall Island debtors as foreign registered companies in the Cayman Islands. And that's an administrative filing with our Companies Office. It can be done very quickly, doesn't require a solvency declaration. And that alone, under our companies law, gives the Cayman Islands Court jurisdiction to scheme those companies and also to appoint restructuring provisional liquidators if necessary. Now, once you've got your jurisdictional hook, there's obviously the question of discretion, whether the Cayman Court is going to be prepared to exercise its jurisdiction. And in deciding that point, the Cayman Court effectively looks at all of the circumstances and looks at the nexus to the Cayman Islands, looks at the wishes of creditors, and looks at the benefits to the debtor and the creditors to restructuring in the Cayman Islands. And for Marshall Islands companies, I think one important and very helpful point in persuading the Cayman Court is that there is no restructuring regime in the Marshall Islands, and therefore there is no natural restructuring forum, and particularly in circumstances where you're talking about shipping, where management and assets and creditors are all over the world. And the Cayman Court in those circumstances has been open, as in the Ocean Rig restructuring, to accepting jurisdiction on that basis, particularly where there's a large level of creditor support. In reality, the other point that helps with that analysis is for Chapter 15 relief, you need to establish a sufficient nexus to the Cayman Islands for the purposes of Chapter 15 in the US Bankruptcy Court. So in establishing that nexus, you're also going to be reinforcing the ties of Cayman, which in turn helps to satisfy the Cayman judge. So Aaron, I might turn it over to you to talk a little bit more about why this nexus to Cayman is important for the US Bankruptcy Court if you're looking for Chapter 15 relief.
Sure, thanks, Caroline. And if we go to the next slide, we'll look at some of the US Chapter 15 considerations. And remember, as Caroline and Nick have said, the Chapter 15 filing completes the circle of the scheme with respect to New York law governed debt by potentially affording the company relief in the form of a stay and recognition in the US to prevent dissenting creditors from taking action in New York under the governing law documents. But in order to obtain that important relief, there needs to be, as Caroline said, a nexus with the Cayman. There needs to be at least an establishment, and if not an establishment, or the center of main interest, or COMI in Cayman. And bankruptcy courts will evaluate the decision-making nerve center, where the nerve center is of the Cayman company that's in a Cayman proceeding at the time of the Chapter 15 case, as a way to determine whether that's where the COMI is, as a way to determine whether the relief that would be afforded under Chapter 15 is going to be done on a mandatory basis, or if it would be on a discretionary basis, or not at all if you've got an establishment or some lesser connection with the Cayman jurisdiction. So it's a very critical initial analysis in terms of whether, in terms of making sure Chapter 15 relief is available. Once you establish that there is that requisite nexus, U.S. bankruptcy courts have been quite robust in recognizing and enforcing consensual schemes of arrangement, including in a way to give effect to the third-party releases that are customary in the Cayman and in the scheme context, as opposed to the U.S. Chapter 11 context. In the Chapter 15 context, the test is much more of a violative of public policy test, which is a high bar. And in New York and in Delaware, third-party releases don't violate public policy, and so these are relatively welcoming jurisdictions when it comes to recognizing schemes of arrangement. So I think the important thing, I think, for Chapter 15 purposes in the scheme is determining how you establish that nexus to the Cayman. And I'm minded, and Nick, you can speak to this, that there are challenges in the context of COVID for establishing that connection to the Cayman.
Thanks, Aaron. And if we have the next slide, there are challenges, but like any good challenge, we can meet them and we can solve them. I think the first thing is what is COMI? And it's the administration of the debtor's interests in a way which is objectively ascertainable to third parties. So as Aaron said, where's the nerve center? Where's the management decisions being made? And do the key third parties, the creditors, know about this? So do you need to shift COMI? Well, I think if you've got a simple Cayman SPV and that's the only entity you're looking to restructure the debt of, it'll be incorporated in the Cayman Islands. There's a rebuttable presumption that COMI is place of registered office. That entity's not doing very much, nothing to rebut the presumption. We don't need to worry about COMI, and this slide drops away in its relevance. But if you have a Cayman company and its interests are being administered elsewhere, you need to make sure now they're being administered in the Cayman Islands. And the red box there, creditor meetings in Cayman, I think that was a crucial plank because the company's interests are the restructuring. And we would hold the creditor meetings in the Cayman, which was quite popular. The beaches are quite nice down here. The weather's quite nice. But I don't think people are getting on a plane anytime soon to come and have their creditor meetings in the Cayman Islands. So is this terminal for COMI to Cayman? And the answer is no. I think the key point is board meetings in Cayman and resident directors. That's where the company makes the decision. So we would appoint a number of Cayman resident directors. They would chair the meeting from the Cayman Islands. Other directors could dial in or use perfectly good video technology to participate. The question will become, how many Cayman directors do you need? Can you appoint 2, or would you need a quorum in accordance with the company's constitutional documents, or would you need a majority? And I think that the jury's out there, although Aaron, you'll be the one before the bankruptcy court arguing nerve center Cayman. So what would you prefer?
You know, more connection. The more connections, the better. If you can get a majority Cayman directors, not just a quorum in the jurisdiction, that's much better, if possible. And then also demonstrating the decisions that are being made by the company. Really, the target is to try to establish management of the business akin to the type of management and control that a liquidator or other official office holder would have if you weren't doing a scheme and you were doing something through a formal insolvency proceeding in Cayman. And the good news is that the Chapter 15 courts look at the time that the petition is filed in order to establish where COMI is. So in the absence of a true bright line test, I think every situation is different, but the more you can, the more connections you can squeeze into Cayman, and the more decisions that can be demonstrated to be made there in accordance with the governing laws of documents of that company, the better.
And so what we do then, we've got our nerve center and we just tell everybody. And luckily now you can use the internet to tell everybody everything, and the internet's not affected by COVID. So ascertainable by third parties is still easy for us to deal with. I mean, when would you need to shift, Comey? I think if you've got a hostile restructuring and you need to lock in your Chapter 15 and your protection in the US early, you shift earlier, and then you would appoint provisional liquidators. And on that application, you'd go straight to the bankruptcy court to get your territorial stay there. I think we'll move on, because Comey, we'll be able to fix Comey if you need to. And if we go to the next slide, what I want to leave you with is the best thing since the scheme. And I know it's hard to imagine there's something better than a scheme, but we've got an upside down scheme now. And this all you need to know about this is it will save you some more money. If you've got a guarantor of all of the debt that you need to restructure, it's possible to use a filing of a scheme for that one entity and deal with the guarantee debt, and the third party releases will contain a mirror release or compromise for the principal debt. So one filing can affect a financial restructuring for the whole group, and this is what we saw in NACDAC. There were no local filings needed, although the foreign side and the foreign opinions were quite crucial there. And Aaron, any problems with this even better third party release from your side?
And I thought the right side up scheme was good enough. Look, this is something that will be tested by bankruptcy courts in light of what's the level of creditor consensus that you've achieved through your scheme. Bankruptcy courts like facilitating deals that benefit the vast majority of creditors. That's a really good fact if you're looking to get the upside down scheme recognized in the US. Another thing to do here is going to be to try to embed in your scheme the factors that courts look at in the US when they're evaluating whether third party releases are important in the US Chapter 11 context. So the contribution of the non-debtor entities to the value of the scheme, the importance of this concept to the overall restructuring, the ability of the fact that the scheme would be completely impaired if contribution claims from the other parts of the group were permitted to survive. All these factors that are going to be essential to the Cayman court analysis, I imagine, would be things to point out and draw out for the purposes of getting recognition in the US context.
So we'll leave you with the best thing since the scheme, which is the upside down scheme, and turn it over to Jonathan and for any questions for us. Obviously, I'm happy to answer them on the upside down scheme.
Well, thank you all for that very thorough back and forth. And I think that we'll have to defer to the audience whether or not they believe the scheme to be the best thing since sliced bread. So please submit your final questions to us now. To kind of kick this off, we have a question that came in. If we have a Cayman scheme and also a Chapter 15 in the US, does the US bankruptcy court stay affect the ability of vessel mortgages to exercise remedies in other jurisdictions?
So I'll jump in on that first, and this is an important thing to mention with respect to Chapter 15 relief, is that unlike in a Chapter 11 case, Chapter 15 relief is territorially limited to the US jurisdiction. So that means if a creditor can exercise rights and remedies outside of the US, as a matter of Chapter 15 practice, the Chapter 15 stay doesn't prevent that. We'd be left with the effect of the Cayman stay, if there is any, to prevent those actions. But Nick and Caroline, I imagine you might have some other solutions to deal with these rogue creditors taking enforcement action outside of the Cayman jurisdiction.
Yeah, I mean, I think, once again, this goes back to your point at the start, Aaron, which is the analysis at the outset. What's your creditor base? Where are they located? Where are your assets? What could go wrong? And in terms of identifying hostile creditors and the actions that they could take outside of the US or Cayman in assets that are outside of those jurisdictions, one of the things you're going to do is look at your debt documents and find out what are the majorities required if creditors want to enforce. And, for example, if you've got large creditor support, if you've got a restructuring agreement signed up, and if you've got, your notes held through a trustee, often in those circumstances, there's not really much that a dissatisfied creditor can do, because the support levels are going to be sufficient that the trustee is not going to act on the whim of one dissatisfied creditor. That dissatisfied creditor could, of course, come to the Cayman court and try to seek a winding up liquidation of the company, but in those circumstances, you will either have your stay to the extent that they are unsecured, and also you will have a sort of a friendly ear from the judge in Cayman who's going to be familiar with the restructuring and the efforts that the company is doing to restructure its debt. I think the other point, Nick, that we often look at is whether we need to get formal recognition in other jurisdictions where we're particularly concerned.
Great. All right, so then one other question that we had that came in was, what impacts are ESG issues having in restructurings today, specifically around recycling in the offshore space? So I feel like you could tackle that as a two-part question if you like.
So, sorry, what was the first part of the question again? SG issues.
What impact are ESG, environmental, social, governance issues, having in restructurings today? Are there any?
I think the short answer is I don't see there's any impact, certainly on what we've been talking about, which is in relation to jurisdiction selection. I mean, are there environmental considerations when you're undertaking a restructuring and you might be appointing new directors, or you've got office holders coming in? Well, obviously they're aware that of the environmental duties and obligations that are imposed upon them by taking those positions, but we don't see them, and we don't expect to see them saying no because of those issues. They'll get over them. And what was the second part of the question again?
And just whether or not I mean, you are kind of answered in your first, but whether specifically around recycling in the offshore space, if you guys had any history in that.
I'm not sure what meant by recycling. Aaron, maybe you've got a good idea.
I don't have a view on recycling in the offshore space in particular. The U.S. perspective on environmental liabilities generally is that environmental liabilities can be quite sticky, and it may not be, you may not be able to shed environmental liabilities through the kind of 363 sale, which is often a tool that's used in the U.S. in order to effectively foreclose or sell assets in the bankruptcy process, and so that's something that may be better dealt with in the plan context, where you've got a bit more of a fulsome restructuring that also has to deal with putting environmental claims in their requisite kind of place in the waterfall to be dealt with in full. So it's certainly, environmental issues are certainly a complicating factor when it comes to restructurings, and certainly if you're doing a financial restructuring on a loan, that may not actually address the lurking environmental issues that may be within the group.
Yeah, I agree. We could address them, but potentially Chapter 11 would be the better fit for them. And in terms of recycling assets, a sale out of a Cayman restructuring, we don't have the same 363 provision, which gives such a clean title. So again, demonstrating the scalpeled nature of the Cayman proceeding compared to the Chapter 11, which is, I'm going to say all singing and all dancing, but I still love schemes, even though you've pointed out two very good advantages of a Chapter 11 over the scheme.
Well, yeah, I would just add a little bit of the ESG point. I do think that, as Aaron said, it's fundamentally a complexity. If by recycling we mean scrapping old rigs, yeah, there very well could be some consciousness by the creditors about what that means from an ESG perspective. We're certainly seeing lenders be more cognizant of ESG issues. I think you could consider that there may be a range of opinions on this matter, depending on who your investors or lenders may be. But certainly it increases the complexity of the situation if there is a view that recycling or scrapping assets is required, and the way of doing it is suboptimal. I don't know if the courts would get involved in that discussion, but I could certainly see that becoming something that people would look to see if they could inject into the litigation if they saw it as a way of gaining leverage, unfortunately.
And I have a question for Greg and Aaron. I mean, the ESG liabilities, presumably in some circumstances, could attach to individuals personally. And in those circumstances, has the US Bankruptcy Court had to grapple with whether they can be released from those liabilities?
So
okay,
not as familiar with the personal liability for environmental harm, but certainly the Superfund legislation in the U.S., CERCLA, and this isn't an area of particular expertise for me, but these are statutes that provide a lot of staying power to the environmental liability. And there's a fundamental conflict between bankruptcy law, federal bankruptcy law, and federal environmental law about on the one hand maintaining liability in the hands of subsequent holders of those kind of polluted assets, and the bankruptcy ideal of fresh start, reorganization, and discharge. And that's an area that is often litigated and becomes quite complex in terms of how capable the company may be of not assuming those liabilities if it acquires assets through a sale process. Because it's an ongoing requirement with respect to the owner. These are difficult. These are not the type of claims that can be discharged through a bankruptcy process.
Okay, and I think we have another question that came in that might be a little bit contentious, and Aaron, you might have to put on your boxing gloves to defend Chapter 11 for this one. So we have a question that says, the fees and costs are high between advisors and lawyers for Chapter 11 for the multiple parties, and usually results in more borrowed money, i.e. dip financing. Another unspoken criticism is that it keeps management, which may have some responsibility, in place and provides them incentive in the reorganized company. Is that a fair statement, or is there a way to work around the issues that I just noted?
So look, the way to work, it's a fair statement, and different restructuring regimes have different approaches with respect to management. In the UK, management is out, and in fact, it would violate their duties to trade while insolvent. So you've got administrators that come in. The US takes the view that the way to maximize value, notwithstanding the faults of management, as long as there was no fraud, is to keep management in place because they know the business, they can operate it, and they can run it most effectively. And in certain circumstances, the distress isn't management's fault. There's COVID. There's surprising systems, things that happen that create unsustainable debt burdens that weren't foreseeable. And so it's a different approach to restructuring, whether you keep management in place or not. As I said, and Nick is right to point out, and the questioner is right, who I think might be Nick, is right to point out the costs with respect to Chapter 11 cases, particularly if there's a free fall, particularly when you're paying for the creditors committee to litigate against the estate. This kind of burns people, rightfully so. So the way to mitigate those costs, if possible, is to try to find a path to as consensual restructuring as possible through an in-court process. If it's a pre-pack, that means you've got what you need before you even file, so you minimize the time in bankruptcy and reduce costs. If you can't get everything you need before you file, you try to at least enter a lockup agreement, so you've got a prearranged plan. And what this tries to do is to put the bankruptcy on a milestone timeline to reduce exactly those costs that the questioner rightly identifies as being a real disadvantage to Chapter 11.
And I'll just step in and say, from the Cayman Islands perspective, you've said there's the US and UK angle, which are at two extremes. The Cayman Islands, the management stays in place if it's suitable for them to do so. They don't if it's not, and you can have a halfway house. So what the Cayman court will say is, all of those approaches have merit. We'll find the approach that fits the case in hand, rather than have to twist the case twist the process to fit the case. And so there's a lot more flexibility in the Cayman Islands for dealing with those issues that the questioners raised.
And I do think that's a real advantage of Cayman to England. One of them is your flexibility in the insolvency regime to have the light touch proceedings available.
We're not going after England here, Aaron. But you can't
Oh, very good. All right, and so I think that we have time for one more question, because we have run over time. But I think, Caroline, you may have alluded to this, but when is it too late to shift to establish nexus? It seems almost too good to be true.
So it's never too late to shift to establish nexus in theory, and I think it's going to depend on the circumstance of the case. So as I mentioned, there is the ability to actually migrate to the Cayman Islands formally, and in order to do so, you have to swear the declaration of solvency, which is that you're able to pay your debts as they fall due. Now, depending on where you are in your debt cycle, you may or may not be able to make that. You may or may not be able to make that declaration. Even if you're not, even if you're not, that doesn't preclude you from registering as a foreign company. So that's the fallback option, or possibly the first option in many cases. So that gets you your jurisdictional hook, as I said. I think the more interesting question is, how soon do you need to get your Chapter 15 relief? Because the Chapter 15 relief is often going to be the real protection for the companies in distress, and they will want to get that in place to stop, for example, a hostile Chapter 11 or even Chapter 7 in the US. And the shifting of your nexus will be, you will need to do that before you get your Chapter 15. Before you can get your Chapter 15. So, for example, in Ocean Rig, there was an acknowledgement that they were likely going to come under fire very early in the process. So we wanted to get Chapter 15 in place at the very start of the Cayman process. So at the time we were filing the scheme petition and the appointment of the restructuring provisional liquidators. So we needed to shift the COMI in advance. In other cases, you don't need to shift the COMI in advance. You can get your Chapter 15 later, sometimes even after, at the end of the scheme process. Or alternatively, if you have restructuring provisional liquidators appointed, that will naturally shift the COMI. I think the US courts have found that to be the case on several previous occasions. And after a couple of months of your restructuring provisional liquidation, you can get your Chapter 15 at that stage.
All right. Well, thank you for rephrasing that and giving an example. So that was very, very helpful. So that's all that we have time for. I want to thank you again, Caroline, Nick, Aaron, and Greg, for a great presentation and Q&A session. I want to thank the audience for tuning in and engaging with the speakers. This webinar will be posted to our site later today, so keep an eye out for that if you want to rewatch it or share it with your friends. We will see you all next time for the next Marine Money webinar. But for now, this is John Shear and the team from Marine Money signing out. And thank you for joining our webinar series. Thank you all.
Thank you.
Thank you.
Thanks, everyone.